Good afternoon, ladies and gentlemen. I welcome you all to the third session of Day 2 of the Delhi Arbitration Weekend 2024. We have now reached the toughest session of the day, which is this present post-lunch session. But let me assure you that all the members of the audience that this is going to be a greatly enriching and insightful session. The topic of the session is Back to Basics, Global Perspectives on Challenges in Enforcing Arbitration Clauses. I have the pleasure of introducing some eminent luminaries here on the dais. It is my absolute pleasure to introduce the chair of the panel, Honorable Justice J.K. Maheshwari, Judge, Honorable Supreme Court of India. Justice Maheshwari, before being elevated as a judge, was a practicing advocate with the State Bar Council of Madhya Pradesh and practiced in civil, criminal, constitutional, and service tax matters. He was subsequently appointed as an additional judge of the High Court of Madhya Pradesh in 2005 and a permanent judge in 2008. He was a part of various committees pertaining to betterment of administration of High Court of Madhya Pradesh and continued his good office till 2019. He was the first Chief Justice of the newly established Andhra Pradesh High Court at that time. He was elevated as the Chief Justice of Andhra Pradesh High Court in 2019 and the Chief Justice of High Court of Sikkim in 2021. Justice Maheshwari then assumed his present office as the judge of the Honorable Supreme Court in 2021. We welcome you, sir. Can we have a round of applause, please? I'm personally very excited to introduce our next speaker on the panel and slightly biased, if I may add. Honorable Justice Sunita Agarwal, Chief Justice, High Court of Gujarat. Before being elevated as a judge, Justice Agarwal enrolled as an advocate with the UP Bar Association. As a lawyer, Justice Agarwal practiced mainly in civil writ, original and commercial jurisdiction of Allahabad High Court. After a dedicated practice of 21 years, Justice Agarwal was elevated as the additional judge of Allahabad High Court in 2011 and thereafter took an oath as a permanent judge in 2013. Justice Agarwal is also a trained and certified mediator. After serving as a judge in Allahabad High Court for 12 years, Justice Agarwal was appointed as the Chief Justice of Gujarat High Court in 2023. Notably, she is presently one of the only few, which is two, female Chief Justice of High Court in India. During her farewell speech at Allahabad High Court, Justice Agarwal said, "If I can do it, you can do too," to young female advocates, and those words have encouraged and inspired many of young female lawyers, such as myself, throughout the country, if not globally. Thank you so much, ma'am, for having her, and also I wish you happy Women's Day. Mr. Vijay Narayan, Senior Advocate. Mr. Narayan is a distinguished practitioner of law hailing from Chennai. He was designated as Senior Advocate in 2004 by Full Court of High Court of Judicature at Madras. He was thereafter appointed as Advocate General of State of Tamil Nadu in 2017. His practice encompasses a wide array of fields ranging from tax to insolvency, banking law, contract, and commercial litigation. We welcome you, sir. So glad to have you here. Our next speaker is Mr. Andrew Onslow, KC. Mr. Onslow is a highly accomplished commercial and banking silk. His main area of practice are general commercial litigation, arbitration, banking, and finance. In recent years, he's acted in many most high-profile cases in English courts. Mr. Onslow regularly sits as an arbitrator. He has given expert evidence in tax litigation in US federal courts and provided opinions for use in various forums. Apart from these, he's also chair and co-chair of many prestigious organizations. He was shortlisted for Commercial Litigation Silk of Year in 2021, Chambers and Practice Bar Awards, Professional Negligence Silk of the Year 2022, Legal 500 Awards. We welcome you, sir. Thank you so much for coming. Last but not the least, we also have on the dais Mr. Siraj Omar, SC Managing Director, Drew & Napier. Mr. Omar practices in complex, high-value commercial litigation, international arbitration. He has an active trial and appellate practice at all levels of the court in Singapore and in international arbitrations. He also sits as an arbitrator in international arbitration and as well as a mediator. Mr. Omar is a member of Board of Directors of SIAC and is a member of the Board of Executive Committee. He's recognized in all leading legal directories. He was appointed as Senior Counsel by the Chief Justice of Singapore in 2019, one of the select few to be accorded this honor. We welcome you, sir. Thank you so much for being here. With that, I welcome all the panelists, and may we have a huge round of applause once again for all the panelists. And without further ado, I hand over the dais to Justice Maheshwari and other panelists to please take it forward. would you speak from time?
Good afternoon, greetings and salutation and very happy International Women's Day to everyone present here. Coming to the topic, back to basics, global representative and on challenges in the enforcing arbitration clauses. So coming to back to the basics, arbitration in Indian landscape has witnessed a sea change over the last 2 decades. In preparatory steps towards the formulating the Arbitration and Conciliation Act 1996, first meeting of the Law Ministers Working Group was held in 1994. Dr. P.C. Rao spoke, I quote, "To make arbitration a source story in India, we need 3 things. A good law that is responsive to our needs, honest and impartial arbitrators, without whom any law can be frustrated, and the litigants, particularly the commercial community that is willing to play the game in good faith." Hence, accordingly, 1996 Act came. It has witnessed extensive legislative intervention through the statutory amendments and authoritative pronouncements from the judicial quarters to bring it at par with the international best practices. The hallmark of the arbitration process, namely party autonomy, minimum judicial intervention, and speedy and efficient dispute resolution, have been the guiding light for Indian courts, albeit with some aberrations which are unavoidable in the diversity and peculiarity of our jurisdiction. The regressive relies of the past have speedily given way to progressive pro-arbitration and pro-enforcement trend, which can be witnessed on a daily basis today. Indian courts are consistent in respecting and deferring the competence and relegating fit matters to the arbitration tribunal for its decision. As the global arbitration community converges in New Delhi with the fervent desire to see India emerges as a vibrant hub for arbitration, the concerted effort of all stakeholders is the need of hour to realize this aspiration. As the topic for today's session suggests, that we will be deliberating and discussing the basics of arbitration process, where the eminent panelists will shed light on the global perspective and challenges in enforcing arbitration agreements. It is my observation that answers to the most profound and complex questions in life and law often lie in the basics. With this in mind, this panel aims to analyze the contentious issues which arises in different jurisdictions and approach of the national courts in the testing in existing validity and scope of the arbitration agreements. An arbitration agreement embodies the fundamental spirit and will of the parties to resolve their disputes through arbitration and lends legitimacy and sanctity to the adjudication process. An agreement to arbitrate can perhaps call the spirit that giveth life and is founded on the cornerstone of free consent and party autonomy. Today's discussion will primarily focus on the impediments faced by arbitration, users in enforcing arbitration agreements across various jurisdictions, and the endeavor to provide some guidance on navigating troubled waters and gray areas. I wish to preface this by stating that importance of the well-drafted arbitration agreement can never be overstated. A well-drafted, unambiguous arbitration agreement ensures the predictability and highlights the parties' clear intention to submit a dispute to arbitration and avoid conflicts. It also ensures that the positive obligations of the stakeholders is preserved, not circumvented by the errant parties. Any discussion on the enforcement of the arbitration agreement has to begin with a reference of Article 2 of the New York Convention and recognition and enforcement of the Foreign Arbitral Awards 1958, which is the grand norm for recognition of arbitration agreements. By ratifying nations and mandates the national courts to refrain from interfering in matter where a valid arbitration agreement exists. These principles are also replicated under Article 8 of the United Nations Convention, International Trade Law, Ancestral Model Law, which has been adopted in India by Section 8 of the Arbitration and Conciliation Act. The international ways and means of constituting an arbitration agreement, which is aligned with the positive obligation to arbitrate, have been succinctly captured by Mr. Grayborn in the following verse. In a substantial majority of all jurisdictions, national law provides the international arbitration agreement should be interpreted in the light of a pro-arbitration presumptions derived from the policies of leading international arbitration conventions and national arbitration legislation and from parties' likely objectives. This type of presumptions provide that a valid arbitration clauses should generally be interpreted expansively and in cases of doubt extended to enormous dispute claims. That is particularly true where the arbitration clauses encompasses some of the parties' disputes, and the question is whether it also applies related disputes so that all such controversies can be resolved in a single proceedings. Against this background, the panel will open the discussion on the contracts of adhesion, multi-tier dispute resolution clauses, which often poses formal and fundamental challenges in the enforcement of the arbitration agreements. Courts generally refuses to enforce contracts clauses and exempt a party from liability for its own fraud or misrepresentation, violations of a statute or public policy, and injuries caused by gross negligence or recklessness. After addressing contracts of adhesion, the panel will analyze vastly the debated controversy, non-compliance with pre-arbitral conditions as an issue of jurisdiction or admissibility of claims. The Indian position in this regard has been slightly dissonant, with some courts taking views that attempting amicable settlement prior to arbitration is merely directory and some courts observing it to be mandatory. However, the primacy is often given to intention of the parties to be deducted from the wording of the clauses. The another growing area of concern that masks the enforcement of arbitration agreements is concept of fraud. In the Indian context, the Supreme Court has laid down the principles of law to make the distinction between serious allegations of forgery, fabrication in support of the plea of fraud as opposed to the simple allegations. Two working tests laid down. Those are, does the plea permits the entire contract and above all the agreement of arbitration, rendering it void? Second, whether the allegations of fraud touch upon the international affairs of the parties inter se, having no implication in the public domain. Another curious area impeding the enforcement of an arbitration agreement can be found in the concept of expected matters. Such expected matters have been considered non-arbitrable in the Indian landscape. An objection relating to the arbitrability of the aforesaid issue would impede the enforcement of the arbitration agreement as well. Even in cases related to accord and satisfaction, where a party may resist the enforcement of an arbitration agreement, it is fairly well settled principles of law that it is always advisable and appropriate that in cases of debatable and disputable facts, the same should be left to the arbitral tribunal. Lastly, it is imperative to touch upon another topical issues, the sphere of enforcement of arbitration agreement that pertains to group of companies doctrine that is often inclined towards impleading non-signatories to an arbitration agreement. The said issue has been recently settled by the Supreme Court, where it has been expressly observed that the referral court should leave it for the arbitral tribunal to decide whether the non-signatory party is indeed a party to the arbitration agreement based on the factual evidence and application of the legal doctrine. In view of this background, I take this opportunity to introduce my panelists. You know, all are here. As it's note to you, the discussion we are starting and inviting the panel on some topics which I am highlighting, and that accordingly the discussion would be of all jurisdictions, Indian perspective, as well as the perspective of the other countries. The topics which we have decided and I have also pointed out in my speech. The first is principles of contract of adhesion applies, and contract provide for multi-tiered dispute resolution process or arbitrations, adding with the effect of non-compliance with a tiered arbitration clause perspective from various jurisdictions. It will be highlighted by Justice Sunita, Justice Vijay, Narayan, Andrew Onslow, and Siraj, Omar. Further, the enforcement of the arbitration clauses in face of the serious allegations of fraud perspective from various jurisdictions, it would be Vijay, Narayan, Andrew Onslow, and Siraj, Omar. The enforcement of arbitration clauses where the subject matter is covered by specific legislation, perspective from various jurisdictions, and similarly the enforceability when the claim is barred by the principles of accord and satisfaction, and the enforceability against a non-signatory. All three panelists will analyze all these issues. With this introductory remark, I invite my panelists to discuss on the issues. Thank you very much.
Very good afternoon, everyone. Wishing you happy Women's Day and happy Shivratri as well. So, Women's Day coinciding with Shivratri gives us a lot of strength. So, all strength to my tribe, all women out there. Coming to the serious business. So, I'll be throwing discussion on two topics. One is issues. One is contract of adhesion, arbitrary and unconscionable clauses. And the other is this multi-tier clauses. So dispute resolution clauses. So contract of adhesion, like basic everybody understands, and I don't have to tell, but still, the basic tenet of a contract of adhesion is like difference between the bargaining power of both the parties to the contract. So one party with superior bargaining power presented to the other party with the idea that take it or leave it manner. So in this regard, the Supreme Court in Texo Marketing, 2023 volume 1 SCC 428, relied on the meaning of adhesion on the meaning given in Black's Law Dictionary, and noted that a standard form contract prepared by one party to be signed by the party in a weaker position, usually a consumer who has little choice about the terms. The nature of the contract itself is such that it raises questions as to whether the weaker party actually consented to its terms. The common characteristics of a contract of adhesion are that it is a standardized format. These contracts are drafted in a standard template. There's no scope of customization, and the content of the contract barely changes. So, this such standardization of the contract leaves no room for negotiation between the parties, with the opposite party or the weaker party having zero bargaining power. So, in relation to whether arbitration agreements in a contract of adhesion can be enforced, we can look to the recent decision in Messrs. ICOM 2019, Volume 4, SCC, page 401, where the Supreme Court, faced with an arbitration clause, which inserted a condition for the deposit of 10% of claimed amount by the party for invoking arbitration clause. The defense was, like, the idea given to the court was that this clause was inserted with the intention to avoid frivolous claim. The Supreme Court said that principle does not apply to situations where both parties are business purpose and the contract is of commercial transaction, and did not agree with the arguments of the appellants in relation to the adhesion contracts. So it was held that adhesion contracts are permissible, but what happened that the Supreme Court has scrutinized the arbitration agreement, which put up the condition of 10% pre-deposit on the touchstone of Article 14, and held that in contractual sphere, where there is involvement of a state party, the Article 14 requirement to act in a just, fair and reasonable manner continue to apply. The court analyzed the clause on test of arbitrariness and concluded that though 10% deposit clause was inserted to avoid frivolous claims, it can otherwise be taken care of by imposing exemplary cost when the claims are found to be frivolous. So the court said that there is one important aspect of the matter which is to be kept in mind in deciding that such a clause would be arbitrary, in the sense of being something which would be unfair and unjust, and which no reasonable man would agree to. So the court also focused on the issue of the refund and said that even if the claim is decided to not being frivolous, the amount that is deposited need not be refunded in entirety to the successful party, and this further makes the arbitration clause wholly arbitrary, excessive, disproportionate, and leading to a wholly unjust result. The other view of the court was that a deposit clause amounts to clog on the dispute resolution process. The primary object of arbitration is to reach a final disposal of disputes in a speedy, effective, and inexpensive manner. So the court concluded that deterring a party to an arbitration from invoking this alternative dispute resolution process by a pre-deposit of 10% would discourage arbitration, contrary to the object of declogging the court system, and would render the arbitration process ineffective and inexpensive. And that is how the court struck down the deposit clause under the arbitration agreement. The issue of contract of adhesion was also touched by the apex court in Vidyadrolia by saying that in non-negotiated take it or leave it contracts, party autonomy is weaker. Hence the legislature must protect the weaker party. In Lombardy engineering, the view taken by the apex court in ICOM Delhi was followed, where the court was faced in an application under Section 11 of the Arbitration Act with an arbitration clause which required deposit of 7% of the claimed amount. The court concluded that arbitration clause must comply with the requirement of the Constitution of India by taking into consideration of the concept of grand norm, Kelson's theory that the rule of law which is supreme and forms part of the basic structure. There cannot be a waiver of the fundamental rights or a consent against the law of the land. So it finally concluded that the arbitration agreement must comply with the requirement of three laws, that is Constitution Law of India, the Arbitration and Conciliation Act 1996 and other legislation, Section 7 of the Arbitration and Conciliation Act, which lays down the condition of an arbitration agreement. So, issue of unconscionability as a precondition in an arbitration agreement, unconscionable precondition in an arbitration agreement was also touched by the apex court in Lombardy with reference to the Uber Technologies, the Canadian Supreme Court judgment. And it is said that unconscionability has a meaningful role to play in examining the conditions behind consent to contracts of adhesion, as it does with any contract. Reliance was also placed on Vegeter, a US court decision where it is held as to procedural unconscionability. So there are two aspects of procedural unconscionability and substantive unconscionability were discussed there. And it is said as to the procedural unconscionability, the court finds that this was a contract of adhesion. The term of contract were not negotiated, and the plaintiff had relatively little economic strength in the transaction. As to substantive unconscionability, the arbitration clause is held to be unreasonable insofar as it requires plaintiff to travel to a particular country there for arbitration. So, in analysis, we can gather that the contract of adhesion and standard form of contracts are generally permitted in India unless they violate any fundamental rights under the Constitution or are unconscionable. In relation to fundamental rights, the arbitration agreement has been tested and analyzed on the touchstone of Article 14 with the aspect of arbitrariness, not on the issue of discrimination. In relation to unconscionability, the Supreme Court adopted the Canadian approach, wherein the test is to examine whether the standard term impairs a party's ability to protect their interest in the contracting process and makes them more vulnerable. So, a balance is sought to be struck between fairness and commercial certainty. As to the multi-tier dispute resolution clauses, sometimes these parties provide that in a certain action or event must occur before arbitration, such as mediation, negotiations, or the lack of jurisdiction of a specific court could be condition precedent to the filing of an arbitration application. The preliminary procedures are designed to help both parties to resolve any dispute before taking the subject to court or arbitration. But some articles often begin with an obligation to negotiate, including bringing in top management or involving top management involving in conciliation or mediation process. The adjudicatory process in such clauses is the final tier to speed up the resolution of disputes, and it is employed that only if the initial stage have failed, the final stage of adjudicatory process by arbitration can be taken care of. We have seen these types of provisions, multi-tier provisions in contracts of construction, service contracts, that need a specialized know-how. A common problem which is realized with these conditions is that when it is unclear whether the provision is merely preferable before the arbitration or whether it is required or mandatory to initiate a proceeding. So it initiated a debate regarding the mandatory nature of the pre-arbitral processes and steps provided under a dispute resolution clauses. So there are discussions on various case laws, and in some cases the court focused on the language of the arbitration agreement and opined that the nature of clause has to be viewed. In Sushil Kumar Sharma, 2005, Volume 6, SCC, page 281, it was held that the steps to be adopted by the parties before the arbitration are mandatory. The procedure should be followed. The arbitral tribunal cannot establish its jurisdiction in case these steps are not followed. There have been instances where the parties have focused on the conduct of parties in analyzing such kind of arbitration clauses. In Visa International, 2009, Volume 2, SCC 55, the precondition for referring any dispute to arbitration in the agreement between the parties was that the dispute should not be able to be settled amicably. It was contended that in order for a dispute to be endeavored to be settled amicably, there must be formal conciliation between the parties. The court there observed that there were several letters and correspondence which had been exchanged between the parties, which ranged over a period of months, and held that it was clearly established that the dispute between the parties could not have been amicably settled, and the case was ripe for reference to arbitration. So the request for appointment of arbitration was accordingly granted. In Swiss Timing 2014, Volume 6, SCC, page 677, several discussions were between the parties and efforts were taken. The court observed that it could not be said that the parties had not made their best endeavors to negotiate to resolve the disputes, and therefore the arbitrator has jurisdiction to look into the dispute. In Tulip Hotels, the Bombay High Court held that where the parties agree to a specific procedure and mode for settling their dispute by way of arbitration and prescribe certain preconditions for referring the matter to arbitration, they must comply with those preconditions, and only then can they refer the matter to arbitration. So, the courts generally, at times, they look at the nature of the pre-arbitral steps itself to arrive at a decision regarding the enforceability of the arbitration agreement. In Sun Security Services, the Allahabad High Court has held that the steps provided therein for a decision by the Vice Chancellor of the university could not be said to be part of the procedure for the appointment of the arbitrator. This is because the pre-arbitral steps was not in the nature of an adjudicatory mechanism and thereby not mandatory. It was held that it was only a pre-arbitration settlement mechanism to prevent dispute going to the arbitrator. Such mechanism cannot be interpreted to be an absolute bar once the parties are sure of the stand taken by the other. The Delhi High Court in in analysis, what we can say is that different factors are considerations when determining whether a pre-arbitral step is mandatory in nature to the extent that it may render the arbitration clause unenforceable. While the language of the clause is undoubtedly important, the courts have ventured into analyzing the conduct of the parties and the nature of the pre-arbitral step to arrive at more practical solutions. So the language of the clause plays an important role in deciding the nature of the pre-arbitral steps. This is how I throw this discussion to the participants, the audience. And I hand over mic to my fellow panelist. Andrew.
No. Now the next topic would be on which we are going to discuss is what is the effect of non-compliance with a tiered arbitration clause perspective from various jurisdictions. So I am giving over to Andrew.
Right. Hello. Right. I'm being invited to talk about this from the English law perspective, and I think Siraj is going to talk about it from a Singapore law perspective. You have heard from Justice Agarwal the sort of clause, the multi-tier dispute clause that we're talking about here. It's a clause that one sees in many, many contracts which provide for settlement negotiations, mediations, matters of that sort to take place before any arbitration can begin. Now, the English law approach to this is now pretty well established. Let's assume that the clause in question is governed by English law. There's essentially I think I'd call it a three-stage process at which different elements, mostly of the sort of common law analysis of contracts, come into play. There are courts who will say that the clause itself is so uncertain that it cannot be enforced. And that's an aspect of long-standing learning and academic study in common law jurisdictions about uncertainty in the formation of contracts. Go a stage beyond that, you have an enforceable clause because the specifics of it are clear enough. So, for example, it is clear enough that the parties are obliged to appoint a mediator, a timetable is set within which certain steps will take place. The question then is, the second stage, if you like, if you get that far, the question is whether it's merely directory, aspirational, a statement of general intention, or mandatory. And by mandatory, I mean it's essentially imposing a condition precedent to the ability to begin an arbitration. And those clauses are common, or not uncommon, and that takes you, if you have such a clause, it takes you to the next stage, which is if you have a clause which essentially makes submission to mediation or settlement negotiations or a particular timetable before you can start an arbitration, a condition precedent by its terms to the right to arbitrate a dispute, then the question is, well, is that a matter of mere what's called commonly now in the English cases admissibility, or does it go to jurisdiction? And the significance is, at any rate in the English arbitration world, that if it goes to jurisdiction, goes to the jurisdiction of the substantive jurisdiction of the tribunal, it will be open to review under Section 67 of the English Arbitration Act. But if it doesn't go to jurisdiction, and let's assume you can't establish an obvious error of law, or you can't establish a serious irregularity in the conduct of the arbitration, it will not be reviewable. And there's been at least 2 recent English cases, surprisingly recent actually, that this hasn't come up for decision before. 2 cases, just mention them, Republic of Sierra Leone and SL Mining, and a case called NWA and FSY, in which the English Commercial Court has now decided twice that such clauses, even if you get as far as being able to construe them, interpret them as conditions precedent, are matters of admissibility and not of substantive jurisdiction under Section 67 of the Act. And there's also been a recent Hong Kong case which has taken the same approach, a case called C&D, the Hong Kong Court of Final Appeal, with some very detailed and interesting judgments from 5 judges on that court. So that's the position is now relatively well established, albeit recently in England. And I expect Siraj is able to help us with the current situation in Singapore.
Right. First, before I begin, let me thank the organizers, the Supreme Court, the Delhi High Court, and DIAC for this invitation. It's always a pleasure to be in India, in Delhi. It's not often that one gets to share the stage with persons of such eminence, so I thank you for the opportunity. On this issue of preconditions, assuming you cross the threshold of having an enforceable clause, and assuming that the requirements or the tiers are mandatory in nature, then you come to what the position is in Singapore law. And the position in Singapore law is settled with a caveat that I'll come to. It's settled because there's a Court of Appeal decision dating back to 2014, so a decade ago, called International Research in Lufthansa, where the court held that strict compliance with preconditions was necessary. And so just by way of illustration, that was a case where there were 2 tiers to the arbitration clause. The clause mandated negotiations, negotiations, and it was quite particular about what form those negotiations ought to take. And the second tier, if the negotiations failed, was arbitration. There was some discussions, and then arbitration was commenced. The jurisdiction of the arbitration tribunal was challenged. The tribunal held it had jurisdiction. That was brought to the courts. The High Court held that the tribunal was correct, went to the Court of Appeal, and it was reversed. And the Court of Appeal then held, as I said, that strict compliance was required. The particular form in which the meetings and negotiations had to take place were not complied with, and so they dismissed, or rather they allowed the appeal on jurisdiction. Why I say the position in Singapore is subject to a caveat is there were 2 cases in 2020, also before the Court of Appeal, where the court looked at this distinction between issues of admissibility and issues of jurisdiction. And just like in the UK, that is significant in Singapore because if a tribunal makes a decision on an issue of admissibility, then that is not reviewable de novo by the courts, whereas a decision on an issue of jurisdiction is. And in both those cases, BBA and BAZ and BTN and BTP, the courts discussed and adopted this distinction between admissibility and jurisdiction. Why I say it's a caveat, it's because the decision in International Research and Lufthansa was not referred to, discussed by the Court of Appeal in either of those decisions. And also both those cases didn't deal with the issue of tiered arbitration clauses. One of them dealt with the issue of res judicata, and the second dealt with the issue of limitation. So query whether if this question were to come before the court, whether the decision in international research would still be adopted. But the position in law in Singapore is that strict compliance is required.
Next, we are discussing the enforcement of the arbitration clauses in the face of serious allegation of fraud perspective from various jurisdictions. So now it will start with the Indian perspective and over to Vijay Narayan, please.
Good evening to all of you in the audience, and happy Women's Day to all the women colleagues in the audience, especially to my wife who has come all the way from Chennai to see this program. Now, I must confess that when the topic was originally circulated to all of us, my colleagues Siraj and Andrew from two different ends of the world were a little puzzled as to what really were the challenges to enforcement of arbitration clauses, because in their jurisdictions, arbitration clauses are sacrosanct. And the minute there is an arbitration clause, then the general rule is to refer it for arbitration. But I mentioned to them that in the Indian context, there are many situations where arbitration clauses are not enforceable or have not been enforced by the courts. And as we did our research, we found that such cases exist in other jurisdictions also. So what we propose to do is we have broken down the topic into 5 subtopics, the contract of adhesion and the other principle of multi-tiered arbitrations has already been presented by Chief Justice Sunita Agarwal, and you have heard the 2 different perspectives from UK and Singapore. We have 5 other topics, and those are: can a contract be enforced? Can a contract of arbitration be enforced when there are very serious issues of egregious fraud? That is one. Then 2, can contracts of arbitration or arbitration agreements be enforced when there is a principle of accord and satisfaction that is operating in this case, or where ex facie the cause of action is barred by limitation? Then next is where a contract, can it be enforced against a non-signatory? Of course, in the previous session, you have heard the whole discussion in detail on the question of the group of companies doctrine. But there are some issues which relate to the enforcement of arbitration clauses, namely whether a contract can be enforced against a non-signatory. Can a non-signatory move the court for arbitration under Section 11 against a signatory or a person who is a signatory to a contract? Can a non-signatory move a court under Section 9? These are all questions that have not really been dealt with by the Constitution Bench, which recently decided this issue. So what we propose to do is to take each topic by topic, and Chief Justice Sunita Agarwal and me will give the Indian perspective, and of course Siraj and Andrew will give the perspective from their respective jurisdictions. So let me first go to the question of fraud. There are cases in India where the Supreme Court has taken the view that if there are very serious allegations of egregious fraud, and the fraud is to an extent where it permeates the entire contract, then the courts may refuse to exercise its power to refer it for arbitration on the ground that voluminous evidence will have to be let in, and it is only a regular court that can do it and not an arbitral tribunal. This principle first came up for consideration in the Ayasami case, which was a judgment delivered by the Honorable Supreme Court. And recently in Rashid Raza, the principle has been reiterated that if there are very serious allegations and the court comes to the conclusion that these allegations are so serious and the fraud is so egregious that it permeates the entire contract, including the arbitration clause, then the courts may refuse to refer it for arbitration and direct the parties to a suit, because it is only a regular court which will be able to appreciate the documents and come to a conclusion where there is, whether there is such fraud of a nature as is alleged. Now, the other issue on this is that the fraud should be such that it involves certain aspects of criminal law also. And in such circumstances, the courts will refer the parties to a court, to a criminal court or to a civil court to prove those allegations, rather than referring it to an arbitral tribunal. Now, both Siraj and Andrew will give the viewpoint from their respective jurisdictions before we go to the next topic.
Thank you. I think the law in Singapore on the issue of fraud is quite settled, but I thought what I would do is talk about a very recent decision. It's a 2024 decision involving an Indian party, which directly relates to this issue of fraud. And this is the decision in Reliance Infrastructure versus Shanghai Electric. Long story short, Shanghai Electric won a significant arbitration award in its favor against Reliance. Reliance then applied to set it aside, and two arguments were raised broadly. One was that the person who signed the underlying agreement, it was a contract of guarantee, didn't have the requisite authority. And the second was that the signature was in any event fraudulent. And that goes to the heart, because if the party who is purported to have signed it didn't sign it, then query whether there was consent, whether the party consented to the agreement. Importantly, Reliance didn't raise this with any force, either of these arguments with any force, in the course of the arbitration proceedings. And that was a tactical decision that it made, because it took the view that its other arguments were stronger, and it was confident in its other arguments. Fortunately, the arbitration tribunal didn't agree and made the award against it. They then raised these arguments of lack of authority and fraud before the courts. And the Court of Appeal was very clear and said that in failing to raise these issues before the tribunal, despite having all its facts, Reliance had effectively waived its right to raise it in support of its setting aside argument. So the moral of the story is, if you have concerns and evidence of fraud, raise it as soon as you can before the arbitral tribunal, because otherwise you might be taken to have waived that right. Now, the Court of Appeal did go on in any event to deal with the evidence of lack of authority and fraud, and it also concluded that on the evidence, those allegations were not made out. So I suppose the point I want to make is, if you suspect fraud and you have evidence of fraud, don't keep that in your pocket, raise it up front. Andrew?
Thank you very much, Siraj. I mean, both Vijay and Siraj are quite right that the position is, as a matter of general approach to allegations of fraud, is as well settled in England as it is in Singapore. Subject to one qualification that's worth mentioning. As far as I know, as a matter of English arbitration law, I may be wrong about this, it's a largely theoretical reservation or exception. If you can establish that the fraud in question goes to the arbitration clause, in other words, there's been a specific attempt by lying or by bribery or whatever it might be to induce acceptance of the arbitration clause, then that in the right circumstances may well be reviewable as part of the substantive jurisdiction of the tribunal. It's happened, I'm aware, but the allegation was made and the court considered it in a US case called the Republic of Philippines and Westinghouse Corporation, but I'm not aware of that issue having come up in an English context. What I wanted just to move on to, though, very briefly, because it very well demonstrates the English approach to the sort of questions we're discussing, is I know those of you who've been diligent attendees at this conference will have heard about this case already, but it's the very recent decision in the case of the Federal Republic of Nigeria and Process and Industrial Development, which exhibited practically every aspect of fraudulent conduct you could possibly imagine. There may have been other aspects, but it's hard to think of them. And really, the fraud took three forms. It was a 20-year contract for the supply and processing of gas between Nigeria and and process and industrial PID, process and industrial development. Throughout the whole process, in other words, the pre-contract stages, the so-called operation of the contract, which never really took effect, and then the whole arbitration, PID had a mole within the Nigerian government who had a significant impact on the process, both of the underlying contract and the arbitration. And was induced to act as she did by quite significant bribes over a long period of time. So one, there was bribery. Secondly, Nigeria established at the trial that there had been deliberate deceit, that they had been lied to before the contract was made, as to its content and as to the readiness of PID to perform the contract. And then thirdly, right on top of that, there was the whole process of the arbitration. And throughout the arbitration, I mean, this is astonishing given the participants. Throughout the whole process of the arbitration, PID were being fed highly confidential and privileged documents that had been produced within the Nigerian litigation arbitration camp. In other words, describing their whole approach to settlement, revealing all their problems with raising finance and paying their lawyers and matters of that sort. And then what's more, on top of that, and a fourth aspect of fraud, their witnesses, PID's witnesses, were held to have lied to the tribunal. So, and then, I know you've heard this before, but there is an utterly, surprising is an understatement, aspect of the whole thing. The counsel, I'm not going to mention their names, but the leading counsel acting for PID in the arbitration, if this had been successful, the award, by the way, was 6.6 billion, which with interest by the time of the court case came to 11 billion, was personally due to receive $840 million US. And the solicitor who was instructing him, if this had all worked, was due to receive a sum of $3 billion. Quite how all this happened is as shocking to me now as it will be shocking to you, and was as shocking to the court, but it did. Anyway, to cut the long story short, the approach, the challenge to the award before the English court was brought under Section 68 of the Arbitration Act, which concerns serious irregularity. And it's not difficult to see, given what I've told you, that there was serious irregularity. What the court could not do was interfere under Section 67 as a matter of the court's jurisdiction, because of the competence principle and the fact that Nigeria were not in a position to challenge the merits of the decision by the tribunal. That said, and I don't have time to go into this now, if you do have access to the judgment, have a look at the closing paragraphs in which Mr. Justice Knowles set out some really he set out some considered and very interesting observations on the aptitude of that particular arbitration process for dealing with that dispute. And in particular, what he drew attention to was the fact that none of this would have come to light, or very little of it would have come to light, except but for the court's powers to order disclosure, both against parties and against non-parties. It's very well worth very well worth a reading as something of a counterbalance to some of the things that are said about the benefits of arbitration. Thank you.
So, Vijay, what I could understand from the discussion is that Rashid Raza, in Rashid Raza, the Apex Court has worked out two working tests laid down, and one is that does the plea of fraud permeates the entire contract, and above all, the agreement of arbitration, rendering it void, And the second is whether the allegations of fraud touch upon the internal affairs of the parties inter se, having no implication in the public domain. And the conduct of the parties has also been given due consideration by the court, saying that one has to see that whether the party wants to wriggle out of that arbitration agreement. So a strict and meticulous inquiry into the allegations of fraud is needed, what is said by the Supreme Court. I suppose this is the Indian perspective in relation to the allegations of fraud. Like merely saying that there are allegations of fraud which would require inquiry into the voluminous evidence and the matter is to be relegated to the civil court, that would not be sufficient.
Would not be sufficient. That's right.
So,
no, this is further added by the Abital Post Studios case. This is further added. This after this Riaz case. Further added by Justice Nariman. So anyway, we have a shortage of the time. So we have remaining 3 subtopics. Those are clauses in the face of serious allegation of fraud. We have heard. Now we are going to the clauses where the subject matter is covered by specific legislation. Next is accord and satisfaction. And third is enforceability against non-signatory. Means you can understand I am talking about section 35. I am talking about section 8. I am talking about section 45. So this is the situation. So we first I will giving to Vijay Narayan. We'll briefly describe this. We all 3 panelists on this with Indian perspective as well as the perspective of other jurisdictions.
So here the issue is whether an arbitration clause is enforceable when the subject matter of the dispute is covered by specific legislations. There are 2 important judgments on this issue. One is, of course, the Booz-Allen-Hamilton case, and the other is the Vidya Drolia case. And there they have taken the view that if the subject matter is covered by specific legislations, and they have referred to examples like disputes relating to rights and liabilities, which give rise to or arise out of criminal offenses. Then 2 is matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights and child custody, where there are special rights conferred under legislations and providing for a special forum and remedy. Then matters of guardianship, insolvency and winding up, testamentary matters such as grant of probate, letters of administration and succession certificates, then eviction of tenancy matters, then patent, trademark and copyright, antitrust and competitive laws, insolvency and winding up, fraud and criminal matters. So in both these judgments, namely the Booz-Allen-Hamilton as well as the Vidya Drolia case, they have carved out exceptions where the courts will refuse to refer disputes for arbitration in spite of the existence of an arbitration clause. On the converse side, there are situations where there may be no arbitration clause, yet the parties will be referred to statutory arbitrations, such as arbitrations under the MSME Act, that is Micro, Small and Medium Enterprises Act, and Telegraph Act, and a number of other similar legislations which provide for statutory arbitrations even in the absence of an arbitration clause. Now, for the perspective from the other jurisdictions, I'll hand over to Andrew and Siraj.
Why don't I go first? And maybe I can offer a slightly different perspective on this issue. This is the question of how does one, or how does a tribunal deal with the issue of arbitrability when the subject matter is or is not arbitrable depending on which law you use. The most obvious and most recent example of this is the case of, in Singapore, the Court of Appeals decision in Anupam Mittal and Westbridge, which I'm sure all of you have heard about, which I've gotten endless grief about, even though I'm nowhere near the Court of Appeal. But in any way, that case is very simple. It dealt The issue was one of shareholder oppression. And of course, in India, these issues are not arbitrable. They are to be dealt with by the NCLT. In Singapore, these issues are arbitrable. And so, just very briefly, the facts, I'm not sure if I'm sure all of you know it, but I'll just briefly go through it. This dealt with the company that owned the website Shadi.com. And Indian company, shareholders agreement dealt or governed by Indian law, Singapore-seated arbitration. And the arbitration clause, importantly, provided that all disputes relating to the management of the company were to be resolved by arbitration. And that phrase, relating to the management of the company, eventually proved critical because the court took the view that the parties had intended to resolve all disputes relating to the management of the company via arbitration, and therefore could not have wanted their agreement to be governed by Indian law, because under Indian law, those issues were not subject to arbitration. I'll cut to the chase. The approach that the Court of Appeal took is that in Singapore, at least, the question of arbitrability, you need to satisfy double arbitrability. In other words, the issue in question has to be arbitrable under the law of both the arbitration agreement and, secondly, the seat. And in that case, in the Mittal case, the court held that in both cases, the applicable law was Singapore law. Singapore law allowed such issues to be arbitrated, and so there was no stay of the arbitration that was granted. So that is how the issue of arbitrability is dealt with in Singapore. Andrew?
Yes, I've only got a few things to say about this. Of course, the third alternative for governing law is lex fori, so the law of the court in which the challenge to the award, for example, is being made. And there's a great deal of academic debate and other debate about what should be the approach to the law governing the question of arbitrability. But I'm also aware that recent Singapore decision that Siraj has been talking about has received quite a lot of attention and comment in England. The only thing I wanted to say is that, interesting, the leading English case in this area is itself, like the case that Siraj was referring to, is a shareholder oppression, unfair, in the context of unfair prejudice, petition allegations with regard to the management of a company. A case called Fulham Football Club, 1987 Limited, and Richards. The cause of action that you're given as a complaining shareholder arises under statute, and there are quite detailed English procedural provisions, statutory provisions as to how you deal with such matters. But the Court of Appeal in England had absolutely no trouble in saying that it was arbitrable. And there are, of course, fields in which the arbitrability of disputes is limited. Consumer litigation, consumer legislation is one of them. Prima facie, an arbitration clause in a consumer contract may be treated as unfair, and so on and so forth. But the general rule, and it won't surprise any of you, or the general approach in England, as in many other jurisdictions, is to treat arbitration clauses generously, and there's got to be a pretty clear set of facts, a pretty clear statute, if you like, that is going to exclude litigation arising out of arbitration arising out of statutory measures from the scope of an arbitration clause. Thank you.
Sorry, can I just make one final point? Just on Mittal, I think it's important, there's been a lot of ink spilt on it, but I think it's important that Mittal does turn on its facts. The law, the test is of broad application, but Mittal does turn on its facts because in that case, if the parties had not used the phrase that all matters relating to the management of the dispute were to be arbitrable, then in all likelihood, Indian law would have applied under the arbitration agreement. The double arbitrability test would not have applied, and the matter would not have been arbitrated. So care needs to be taken. This was a point made by the Court of Appeal. Care needs to be taken in how you phrase your arbitration clause. Thank you.
We have a short of time, but in addition, I would like to say on the principle of accord and satisfaction. I will analyze it. I'm not going to analyze in detail. On accord and satisfaction, it is at present, it is a very gray area, and everybody is required to discuss on this. So I will end by this NTPCL recent judgment on 10th of April. The Supreme Court on the point of the accord and satisfaction relied on nodal networks and held a simple narration of the bare facts as indicated above leads such to conclude that the allegations of coercion economic juris are not bona fide and that there were no pending claims between the parties' submission and arbitration. The respondent's claim fits for description for an attempt to initiate ex facie, meritless, frivolous, and dishonest litigations. So the principle of accord and satisfaction have been made applicable. Because we have short of time, only 9 minutes have been left. So we open the discussion on floor and the question answer session. Please.
So good evening, everyone. My name is Yogesh Gupta. I wanted to ask a question on a multi-tier dispute resolution clause which finds space in most of the construction contracts especially, and when we deal with the FIDIC contract also. So in my analysis, there are 3-level dispute resolution clause, which is the first analysis by engineer, second by DAB, and third is an arbitration. So my question is that once 2-level of multi-tier dispute resolution clause is engaged within the parties, it is not exactly a dispute in terms of the arbitration. By the time the parties reach to the arbitration level, there is already a time of 1 year, 2 years already lost. And the first issue which any party faces, the party invoking the arbitration, is the limitation on raising the dispute. So any thoughts on that point?
Sunita, multi-tier disputes, subject use.
I suppose your question was that this time taken in the prior to the parties goes to the invoke the arbitration clause, the time taken in approaching the other party or trying to conciliate, and then the question of limitation comes in, and that is why the Supreme Court in all those matters which I have pointed out, that the conduct of that previous act of the parties prior to they go to the court invoking arbitration clause, that those correspondence, conduct of the parties, and one of the parties trying to conciliate, other party is not coming forward, all those can be taken care of. And the court said that in this kind of situation, the court refused to agree to the objection of the other side, that the first layer or first clause, the pre-arbitration clause of conciliation or this mediation has not been followed.
No, I will add on this. The answer you will find in Geo Miller and Company Private Limited versus Rajasthan Vidyut Utpadan Nigam Limited. In this judgment, they have analyzed the point, breaking point. This analyzes a principle of breaking point. So I'm adding this in addition because of the 5 judgment SPS Limited. So then thereafter this judgment has come to answer this. Otherwise, earlier judgment of Delhi High Court. So that was on a point. And this point was raised in Delhi High Court judgment. If the issue of limitation arises, then what would be the situation in multi-tier system? So this is answered in Geo Miller somehow.
Yes,
so
sir,
I'm adding this much. Next question, please. Yeah. We have some sort of time.
Can I just make a practical comment? You shouldn't be too happy to add many tiers to your arbitration clause. I think you need to look at your contract, look at the particular types of dispute that can arise, and then ask yourself, do I need 2, 3, 4 tiers? So don't be too trigger happy in tiers.
Please, next question.
the Honorable Tribunal, thank you so much for this articulation of wonderful topics, series of topics.
Please, can you come directly on the question?
My name is Colonel Bishnoi, and I am practicing advocate of Bombay High Court. I am FIDIC qualified, so I am just adding to that the point which was said was the dispute was referred as not the dispute before the engineer or the DAV. So I want to just add the dispute or the matter or the grievance is all the same, it remains same, whether it is the engineer or it is DAV or it is arbitral tribunal. Thank you so much.
Thank you. Any next question, please?
Any other questions?
That was not a question, rather answer.
Thank you for enlightening.
Thank you. Thank you so much, sir. Thank you so much, members of the audience. I realized that I rushed through the introductions because I was afraid to eat into the time of the speakers. But now I'm going to take some time to just thank the panelists. I thank each and every panelist for gracing us with their presence today. And thank you so much, everyone. Before we depart at the end of this very insightful session, I would request Justice Bakro to felicitate the distinguished speakers. Thank you so much, sir. Can we also have a round of applause, please? Thank you. Thank you so much, sir. Thank you so much, everyone, members of the audience. There is a short 10-minute coffee break, but I would request everyone to please come back here by 4:15 when the next session starts.
Yours in the front, yeah. Yes, put that down.